exercise in utter frustration. That is how a federal judge described the Trump administration's refusal to provide information on the ongoing efforts to facilitate the return of Kilmar Abrego Garcia. It's been 43 days since Judge Paula Zinnes ordered the administration to return the mistakenly deported Maryland man home from El Salvador, and 37 days since the Supreme Court ruled that the administration must work to bring him back. But in a hearing yesterday, the judge slammed the government, saying its efforts to comply with the order were inadequate and that the government did not explain why answering even basic questions on the case would be considered protected under state secrets privilege, as it claims. The judge argued, quote, "There is simply no detail. This is basically take my word for it." And last night, the judge released her order giving the administration 1 week to provide further evidence to support the State Department's assertions of the state secrets privilege. In the Trump administration's ongoing battle with the courts and the rule of law, the take my word for it approach seems to be a common theme. Ala Vitale and Kimberly Atkins-Storr are back with us. Kimberly, I think you're the only attorney at the table right now.
Yes, I will wear that proudly.
So I would love your reaction to Judge Zinnes, but also this take it for, what was it? Was it take it from me?
Yeah.
Right? Take my word for it. Take my word for it. Is that a legal strategy?
It is not. And what I am seeing from this, now state secrets has entered the chat. This seems like someone at DOJ is going through a book and saying, what possible defense? Okay, what have we done yet? Let's try state secrets. I mean, they seem to be throwing anything at the wall and seeing if it will stick in an effort to obstruct the orders from district court judges writ large. What I'm concerned about beyond the safety of Mr. Abrego Garcia at this point is the fact that when it comes to trial court judges specifically, the administration seems to just be saying, we don't have to do what you say. Mm-hmm. You don't stop us, which is in itself part of the constitutional crisis, right? The executive is supposed to abide by the judiciary. But I think the increasingly lack of patience on the part of judges like Judge Zinnes, on the part of the justices of the U.S. Supreme Court, which just last night slapped the administration again, saying, we said what we said, stop deporting people without process, we're not going to say it again, is really building up to a point that you're going to get a showdown, and I'm expecting at least contempt hearings to start soon.
So now that's my question, because I keep seeing the red line being moved over and over and over again, right? At the beginning, the judges were like, you have to bring them back now. And then it was like effectuate, and they were trying to figure out the words. And what does effectuate actually mean? Right. And now, the exact same kind of thing is happening. Like, I'm getting pissed at some point. You're going to have to do it. Is that them building evidence that the White House is kind of, and the administration isn't doing what they're saying? Or are they just kicking the can down the road over and over and over again?
I think what is happening are federal judges would be very, very wary to go to the point of contempt with the administration. They know how important that is, but that doesn't mean they won't do it. They have in the past. One thing that I think is the big elephant in the room here is once you start with contempt hearings and contempt orders, then you quickly have to move to the issue of immunity. Remember, the Supreme Court gave Donald Trump immunity. And then very quickly, they'll have to decide the issue of how far does that immunity extend? Is it just for Trump himself, or does it also include other members of the administration helping to carry out this under his orders, under his authority? And I think that's something that the Supreme Court probably does not want to take on right now, but I think they're going to have to, because at some point the judges will have to start drawing that line and having some consequences for the administration when they continue to step over it.
So you bring up this idea of like that scenario that we've never been here historically. When you are on the Hill, what are you hearing specifically when they're saying, wait a second, he keeps, to Eugene's point, moving the goalposts. He's not abiding by the judges. He's not abiding by our congressional power. What does that front line look like?
There's some really fascinating dynamics here. Look, we know that Democrats are saying, and I'm sure Jamie Raskin later in the show will say this too, as someone who used to, I think, teach constitutional law.
Yes, exactly.
Scholar. Society for the Rule of Law, and Michelle Goodwin, a constitutional law and global health policy professor professor at Georgetown Law School. Thank you both very much. I'm sorry, I chuckled at the end of hearing Justice Kagan because it's like, if she were a nun, she would have had a ruler and been rapping folks on the knuckles.
Right. She's a former Solicitor General, so she knows what she's talking about.
Right, she knows what she's talking about. And so, Michelle, I'll come to you first. Your reaction to Justice Kagan and what she had to say.
Well, she was on point, and so was Justice Sotomayor and Justice Ketanji Brown Jackson. Look, this has been settled since the Reconstruction, that individuals that are born on these lands are people who are designated as United States citizens. It's been challenged before. In the Young Kim Ark case, it was settled before the United States Supreme Court, and there are other cases that make this clear. The reason why the Trump administration is seeking to do this procedurally rather than on substantive grounds is because they know their hands would be slapped again, and it's an effort to chip away, chip by chip.
George?
I absolutely agree with all of that, but there's another layer to it, which is Donald Trump. You got this is the worst possible case, and that was Justice Kagan, former Solicitor General Kagan's point, to bring up to the Supreme Court on the procedural, technical issue of when you can issue a nationwide injunction. You want to go up on a case where you have a chance at winning, and where the court thinks that ultimately your position is right.
So why did they bring this case?
Donald Trump, because let's say you work for Donald Trump, you're the Solicitor General, okay? And you want to go and say, Donald Trump, look, I won something for you, okay? Because you don't want to go and see the president say and explain like, well, we lost because you took a stupid effing position. Right.
That wouldn't go very well.
You want to say, look, it's amazing, we won this. And it's like everything else. It's fake. It's like it's like the deals. They're all fake. Everything's fake. And this was an attempt to create a fake victory, thinking that the number of the justices don't like nationwide injunctions, and there's good reason to. It cuts both ways.
Right. That's right. We could have a legal seminar. That's true.
But I think one of the challenges here is that even Kavanaugh stepped in. Yeah. One of the biggest challenges, Michelle, is that yes, they may not like injunctions, but at the same time, what they are advocating then is creating a balkanization of justice depending on what state you live in. I could be in a blue state and all of a sudden have American citizenship if I was born here, whereas I could go across to let's say Arizona. So what does that mean with this balkanization of justice?
Well,
what would it imply?
It's problematic from the start. So before we even have the current Constitution that we have, there was already something that was in practice, but it was struck down, and we got the Constitution that we have because there was the balkanization. You're in this colony, now you go over to this colony, and there are different rules. There was a sense of we are a united space, and in this united space, people should be able to travel between these two places without their citizenship being checked, because that was the problem with the Articles of Confederacy from the start.
Well, because then all of a sudden this could also spill into trade, right? So you go from one state to the next and all of a sudden have different tariffs. It's like the rules
we also see this playing out right now. Just this week, there was a case involving a mother and daughter who had moved from one state to the other. The father is coming. They are American citizens. Right. They were probably spied on by neighbors, because who else would have called law enforcement and ICE on them? And in the middle of the night, half-dressed, this mother and daughter, everything swept out of their home, and they were crying on camera saying, but we are citizens. We are citizens, and that's the problem.
Well, and they confiscated their life savings, everything. And they're saying, go take it up with a judge. Really?
Exactly.
One thing that Justice Ketanji Brown Jackson said was very interesting to me. Let's play that, and we'll get your reaction on the other side.
Your argument seems to turn our justice system, in my view at least, into a catch-me-if-you-can kind of regime from the standpoint of the executive, where everybody has to have a lawyer and file a lawsuit in order for the government to stop violating people's rights. I don't understand how that is remotely consistent with the rule of law.
don't understand how that is remotely consistent with the rule of law. What we have seen over the last few months is the justices over and over and over again speaking out more than maybe they ever have before. You guys would know better than I. But what does that tell you about what not just the liberal justices, but some of these conservative justices, where their heads are at with this administration?
Well, there's something that it's not a real legal doctrine, but it's something that law professors and lawyers talk about, that the government has usually an advantage in litigation because there's something called, again, it's not a real legal doctrine, the presumption of regularity. You trust the government more than you trust other parties because they take the same oath you do as a judge to be faithful to the Constitution. You assume that the Justice Department isn't a bunch of lying scumbags. You assume they're telling you the truth. Okay?
It's a family show, George.
They are testing that proposition, and that's what we see both in the yesterday's decision that the Supreme Court issued, and in the Alien Enemies Act argument. Not the Aliens Act, the Birthright citizenship argument, because they're wondering you're not doing this for the legitimate reason of, trying to stop forum shopping, which would have been any other normal administration. You're doing it so you can jerk the courts around, which you have been doing, which is why we keep hearing all these crazy cases that come up. And they're losing their patience.
Are there actual consequences, to jerking the court around?
Well,
like yesterday.
Well, there is. And there are consequences to Americans and there are consequences to the court because it takes up time. I mean, these are cases that, as Justice Kagan said, you're losing, which is stop, because you're actually not only wasting time, you're wasting resources, because in each one of these instances, what the justices were saying, do you really expect every person across the United States to bring a case, get a lawyer to come before a tribunal and say, I'm an American? Because that's what we're facing with this.
Even in a case where there is zero probability that the government's position is going to be upheld by any court in the land, from the district court.
This is what it's going to be, guys. The Trump team are going to continue to make awful arguments because the Trump lawyers, whether they believe it, some of them probably do, or whether they know it's their only argument because they don't have the facts, the precedent, the law, decency, sanity on their side, they have to act like Trump's a king. They have to. Either because they believe it, they actually believe Trump is king, which some MAGA cultists do, but others that don't necessarily believe that understand that you can't make an argument based on the facts, so you have to operate under the assumption that Trump is king. So what, when they're basically saying, take my word for it, or you'll just have to trust that if you carve something out for Trump that he won't further exploit and abuse the good faith you've given him. The judges aren't buying it, and that includes Supreme Court judges. You heard it in the ruling hasn't come down on that case yet, but you saw the Supreme Court crush Trump, but you saw Coney Barrett and others basically say, well, if we give you an exception here to do X, Y, and Z, won't you just continue to be bad faith? Like you already have been. There's centuries of precedent, but there's also Trump administration precedent. And one thing I've talked about on this channel, this is where the courts have been snapping back at Trump, is that so much of the president's powers, the president, the office of it, the presidency, a lot of it is based on the hope that the president isn't an a-hole. And not to be too glib, but you know what I mean? A lot of the power was just trusted to the president. And it's what if the president's an a-hole? Where you ask yourself, it's well, then you're kind of screwed. And this is why the courts have been saying that we have to clamp down, because Trump is the baddest faith president in modern American history.